Morning to everyone.
Great, thanks so much, everyone. My name is Lisa Krickler, and I'm an associate in Norton Rose Fulbright's Johannesburg office. And I am going to be discussing this judgment of 43 Air School Holdings versus AIG. And it's a Johannesburg High Court judgment dealing with the sort of now infamous COVID-19 business interruption claims under that business interruption non-damage extension, which I'm sure everyone here is familiar with. And the court had to interpret the contract of insurance and also consider the nature of composite versus joint insurance. And quite a lot turned on the rather complex facts of the case, but I tried to pull out the more important principles for us to discuss because those are the things that actually have application in other matters. So there were a number of applicants, and their relationship with one another and their group structure was itself quite complex. But suffice it to say for now that the applicants were all separate juristic entities, and they were part of one business structure who worked together to offer training to aspirant pilots, and that the second applicant, 43 Air School, was sort of the cornerstone of that group structure. The policy included business interruption cover from the 1st of July 2019 to the 30th of June 2020. And of course, the applicants alleged that they suffered losses because of the COVID-19 lockdown that began on that fateful day of 26 March 2020. 43 Air School, who, as I said, was the cornerstone of that group structure, submitted the claim, which the insurer then rejected. And the insurer said that because 43 Air School and the other applicants were all separate juristic entities carrying on business at separate locations, they could not rely on 43 Air School's claim under the policy to claim for the same incident. And the court looked at what the various applicants' roles were within this business, and it noted that one applicant offered training, another operated a pilot preparation service for another applicant's students, and then yet another provided flight simulators for use during another's training operations. So they were all very interlinked. 43 Air School, who submitted the claim, was the one that conducted most of the administrative management for all of the other applicants, and was in fact the one who completed the insurance questionnaire that was submitted to their broker and to the underwriter each year. And importantly, 43 Air School had included various premises that were used by the other applicants in the questionnaire, but it's not actually clear from the judgment itself whether all of the applicants were listed as insureds under the policy. And when interpreting this policy of insurance, the court considered what the Supreme Court of Appeal said in the Guard Risk versus Cafe Chameleon judgment. And in that case, possibly you will all recall, the Supreme Court of Appeal reiterated that because insurance contracts are contracts like any other, they must be interpreted having regard to their language, to their context, and to their purpose. And so a court that's tasked with interpreting a contract of insurance, as well as a normal contract, must establish what the parties intended, having regard to the words that they used in light of the document as a whole, as well as the factual matrix within which they concluded that contract. And courts will also try to adopt a commercially sensible meaning over one that is insensible. And unlike other contracts, and as we all know, because insurance contracts are contracts of indemnity, they will be interpreted to this end where they can be, and courts will tend to construe contracts of indemnity in favor of an insured. So what did this contract actually say? Under the definition section, business meant any activity of the insured, and premises meant any premises used for the purposes of the insured. And business interruption cover extended to an outbreak of an infectious or contagious disease within a 25-kilometer radius of the premises. And the court found that business was all of the places that business was conducted, and the question of where business was conducted was a factual determination. And the court also found that on the facts, where there was a case of COVID-19 within that relevant 25-kilometer radius of 43 Air School's premises, then all of the applicants were affected by that loss because they were so interlinked. And it was clear that one event affecting one facility had affected others as well, because the applicant's operations across those facilities were so intertwined. Then, on this issue of joint versus composite insurance, the court again referred to the judgment in Cafe Chameleon and found that on that flexible common sense approach to interpretation that was set out by the Supreme Court of Appeal in that matter, there was actually no bar to the claim where the applicants, although they were separate juristic entities, shared the same facilities to conduct training for support and for ongoing or secondary training. The court said that not to interpret the contract of insurance in this way would lead to an absurdity, which the insurer could not reasonably have contemplated and which the applicants almost certainly did not contemplate. So the court therefore found that the fact that 43 Air School had submitted the claim did not bar the remaining applicants from recovering under that policy. So what do we think? I think that the fact that the court, or South African courts, are empowered now to construe contracts of indemnity in favor of an insured, coupled with this flexible common sense approach that the SCA set down in Cafe Chameleon, means essentially that where a court can find in favor of an insured, it will tend to do so. And in this matter, it's a bit of a shame because it meant that the court didn't really grapple with the underlying principles, of the issues of joint versus composite insurance as much as they certainly could have, but instead glaze over those issues in favor of this common sense approach. And I just want to note that the court did grant the insurer leave to appeal the judgment to the Supreme Court of Appeal, particularly on the issues of interpretation of the contract of insurance and on this issue of joint versus composite insurance. So we'll just have to wait and see what the SCA says on appeal. But in the meantime, I think it's just very important to note that everybody in the chain, from the insured to the broker to the insurer, they all need to be on the same page regarding what is covered, what isn't covered, who is covered, and who isn't covered. Because courts will go through these contracts with a fine-tooth comb, and litigation is not really the right time for the parties to discover or determine what the contract actually meant and what it covered. So an interesting judgment. We'll have to see what the court says on appeal, but if there are any questions, otherwise, Mike, if you have any comments.
I think this is a very important case for brokers because it is at the underwriting stage where brokers are negotiating with underwriters that the identity of the insureds needs to be determined, and the broker has to discuss with their insured who do they need to insure, are the companies interrelated, and to what extent do the companies rely on each other? Because in this case, that was very important. Certain premises were used for certain things. If certain premises weren't available, you could use other premises. So I think that interrelationship had not been examined as much as it could have been, and that's just a warning.
Yeah.
Thanks.
Agreed. Thanks, Mike.
Okay, next person.
Thanks, Lisa, and good evening to everyone. Thanks, Mike. So my name is Nomonde, and I'm also an associate in our Johannesburg team. I'll be presenting to you on the Normadine Farms versus SA Fire Crop Protection case. And this case speaks on material misrepresentations and non-disclosures. Next slide, please, Lisa. So very briefly, the insured in this case, Normadine Farms, instituted an action against SA Fire Crop in relation to a claim arising from a fire on the insured farm in May 2015. Normadine alleged that the fire caused damage in the sum of about 14 million rand. And here, the policy was taken out in 2001. In the 2015 renewal proposal form, Normadine answered no to the question of whether there were any factors that had increased the farm's fire risk since the last proposal form was completed. Ultimately, Normadine's claim was rejected in June 2016 on the grounds that they had misrepresented which portion of the of the farm the fire had originated from. And in this regard, SA Fire alleged that the fire started in a sawdust and timber waste area, and that Normadine had failed to mention this waste area in the renewal proposal form. Secondly, SA Fire alleged that the waste area required a fire break of about 30 meters wide around the immediate exterior perimeter, and that Normadine had failed to maintain this fire break. In light of this, then, SA Fire contended that this misrepresentation was material and entitled it to reject the claim. So the issue then to be determined in this case was whether there was a material misrepresentation or non-disclosure. And in this regard, the court highlighted a twofold test. So the first leg of the test is objective, and this is where we consider whether the reasonable person would think that the risk should have been disclosed to the insurer. In the second leg, which is a subjective test for inducement, we consider whether the particular insurer was induced by the material non-disclosure to issue the policy. Next slide, please, Lisa. So in deciding then whether or not Normadine had a duty to disclose the waste area, the court considered the following. Firstly, it was common cause that Normadine had at no stage informed SA Fire of the sawdust and timber waste area, and SA Fire contended that this was an increased fire risk. Secondly, and in November 2015, SA Fire was convinced that the fire had originated from the sawdust and timber waste area. However, no mention was made of this to Normadine up until June 2016, when the claim was ultimately rejected. To the contrary, SA Fire inquired from Normadine what the salvage value would be of the timber that remained after the fire. Lastly, and despite its conviction, SA Fire's investigations into the fire were very lengthy, and this was indicative that they themselves were not sure where the fire had originated from, and also of their decision to reject the claim. The court went on to state that the onus of proving materiality lies on SA Fire, and it is an objective test viewed through the lens of a reasonable person. Accordingly, the question then was whether a reasonable person in the position of Normadine would have considered it necessary to inform SA Fire of the waste area. And in this regard, the court noted several things. Firstly, the dumping at the sawdust and timber waste area had been taking place for approximately 12 years, and in those 12 years, no fire had occurred. Taking this into account, then, a reasonable person would not deem it necessary to have disclosed the waste area. Secondly, even if it was accepted that the waste area did increase the fire risk, it was also accepted by SA Fire's own witnesses that it was not necessary for such risk to be reported. On the third consideration, the court stated that if it was such a serious concern which needed to be reported by the reasonable person in the position of Normadine, as was alleged by SA Fire, then one would have expected that SA Fire would have immediately raised this with Normadine and not waited until June 2016 when the claim was ultimately rejected. The last consideration, which also considers whether if the fire risk was so serious, then it should have been contained in the policy. Now, the court here did not really get into the second leg of the inquiry on the subjective test for inducement because the requirements in the first leg had already not been met. However, the court considered the factors that I've just mentioned, and they noted that SA Fire failed to prove the disclosure or non-disclosure of the waste area, and to show that this would have affected its decision to insure the property. On the evidence, the court therefore found that Normadine was not guilty of a material misrepresentation or non-disclosure, and that the insurer, being SA Fire, was then ordered to pay the claim. Next slide, please, Lisa. And so the key takeaway in this case is the test for a material misrepresentation or non-disclosure, which is a twofold one. In the first leg, which is objective, we consider whether a reasonable person would have disclosed the risk. And then we move on to the second, which is a subjective test for inducement, where we consider, was the insurer specifically induced by the non-disclosure to issue the policy? If there are no questions, I will hand over to Priyanka.
I'm just going to comment briefly. The judge himself got confused between the whole question of non-disclosure at the initial stage of entry into the policy and on renewal, because what should have been argued is that they were induced to enter into the contract as a result of this non-disclosure. If this had been disclosed, then they would not have entered into the contract, and therefore you would avoid the contract. And the answer thereto would be not to reject the claim, but to say there is no claim to reject because there's no policy. However, in the policy itself, there was a term requiring advice as to change of risk. If they were going to rely on that, then they would be entitled to reject the claim. A problem here is that the person involved in the survey, in handling the claim, and in underwriting was the same person. And they were subject to survey. I see that there's a question. They were subject to a number of surveys, and the person that was cross-examined visited this farm a number of times, and the court showed doubt as to whether she would not have seen the heap of sawdust, especially as this was a mill. The mill would have piles of sawdust around, and it seems inconceivable that she, having visited this place, I mean, a multitude of times, would not have seen this. So I think this is one of the reasons why the court said, well, you've been there so many times and you didn't see anything that was a risk, and you must have seen some of the sawdust. Also, it's interesting that they led evidence that a pile of sawdust is not more flammable. I mean, that is a bit doubtful. I've seen expert summaries to the contrary. But the main thing that one needs to take away here is, if you think there is a non-disclosure, or if insurers think there is a non-disclosure, they must raise it immediately, because the insured said, you've taken so long and you've acted in such a manner that you've waived your right to rely on non-disclosure. The court found that they had not delayed long enough for there to be a waiver, but the way in which they behaved did not suggest that there was any non-disclosure to something that was material, and that they would not have thought that was material because they took too long to raise it. So that's just a lesson for insurers. Thanks. Priyanka?
Good morning, everyone. I'm Priyanka. I'm an associate in the insurance team in Johannesburg. And today I'm going to speak to you about the Discovery Insure Limited versus Masindi judgment. It is a June 2023 judgment out of the SCA. And in this, well, this is actually one of the really fun and interesting ones, well, sort of, in the sense that it answers the question of, does fraud unravel all? And in this instance, the court dealt with fraud, retrospective cancellation, as well as interpretation of contracts. And what happened was, in this case, the insured took out a policy for specified insured risks, insuring his dwelling and his household contents. And the policy provided that if the damage to the residence rendered it unsuitable for human habitation, Discovery would then be obliged to compensate the insured for all out-of-pocket expenses relating to emergency accommodation. The policy also permitted Discovery to cancel with the policy with retrospective effect from the date of the reported incident or actual date of incident if the claim or any portion thereof was fraudulent. So the insured submits a single claim under the business section of the policy for losses caused by storm damage to his residence, And the first and legitimate component was for the cost of repairs to the residence and damage to his household contents. And then the second component was for emergency accommodation. So the claim for the emergency accommodation was the part that was tainted by fraud, and this was undisputed. So Discovery paid the entire claim in full, which was just over 1.5 million rand, with 675,000 rand of that sum relating to emergency accommodation. So it's paid, then evidence of fraud comes to light. Discovery then notifies the insured of cancellation of the policy with retrospective effect from the date of the incident that triggered the claim, as it was entitled to do in terms of the policy. Discovery also then claimed repayment of the full amount already paid out to the insured, as was permitted in terms of the policy. The High Court held that Discovery was not entitled to repayment of the full amount claimed and was only entitled to payment of the amount that was undisputed, that was fraudulent, basically. And the basis for this decision was that the insured had acquired accrued rights to the payment of the genuine portion of his claim, and those rights remained intact, unaffected by the subsequent fraud. Now, the policy clause that provided for forfeiture of claims tainted by fraud was, for all intents and purposes, according to the High Court, a penalty clause in terms of the Conventional Penalties Act. The High Court held that permitting Discovery to recoup the entire settlement sum would result in disproportionate prejudice to the insured, and on that basis, the forfeiture clause was non-enforceable in respect of the valid portion of the claim. So the SCA was tasked with considering whether the partly fraudulent and partly genuine claim arising from the same incident resulted of the forfeiture of the claim in its entirety, and if so, whether Discovery was entitled to repayment of the amounts already paid to the insured in settlement of the claim when it subsequently discovered that part of the claim was tainted by fraud. The SCA noted that insured persons have a duty to act in good faith in their dealings with insurers, and that willfully lodging a false claim constitutes breach of the duty of good faith, which in turn entitles the insurer to terminate the policy. The court also said that generally, in the absence of an express term to the contrary, willfully lodging a false claim relieves the insurer of its liability under the policy from the time of termination of the policy, although rights and obligations that accrued before termination would remain unaffected by the termination. The court also held that fraud clauses, including forfeiture clauses, are common features in insurance contracts and are enforceable. They are designed to protect the insurer against fraudulent claims and to discourage inflated claims by insureds. If an insured submits a fraudulent claim which is then paid out, the insurer is entitled to recover the full amount paid out to the insured. In this instance, the court held that the relevant clause was clear and unambiguous and created the right for the insurer to terminate the policy retrospectively from the date of the incident which gave rise to the claim, not only on discovery of the insured's fraud. So this ultimately led to the insured forfeiting all amounts already paid after the date on the incident which gave rise to the claim. So no insurance policy existed when the insured purported to submit his claim because it had already been terminated with retrospective effect from the date of the incident. So in this instance, the incident happened on the 30th of November and the insured put through the claim on the 31st. And so technically no contract existed because Discovery terminated from the date of the incident as it was entitled to do in terms of the policy. It was also entitled to a refund of all the amounts previously paid to the insured. And in this instance, importantly, the court did not consider whether it constituted a conventional penalty in terms of a penalty clause in terms of the Conventional Penalties Act, because that issue was never properly canvassed or argued or pleaded at the trial by any of the parties. The High Court unilaterally dealt with it and the SCA chose not to. And what is our takeaway here? Insurers are and remain the masters of their own policies. In this instance, the fate of the litigation hinged on the meaning and interpretation of the clauses in the policy, And insurers unilaterally devise their policies and are entitled to and should include appropriate clauses to protect themselves against fraud by, firstly, providing for forfeiture of benefits under the policy retrospectively, and providing for recovery of all benefits paid in settlements of the claim where the claim is tainted by fraud and discovered after payment of the claim. And that is the essence of this matter. We're happy to field any questions. And Mike, if you have any comments.
I do. Before I make a comment, just on the previous matter, a question. The forest and the mill were together. So there was a mill in the forest, and that's how the whole problem arose. There's a question also on motor vehicle extras. That doesn't arise with any of the matters that we're dealing with now. So if there's time at the end, we can discuss that aspect. What is important about the Discovery Insure Limited is the whole question of fraud clauses. And it's necessary to understand why fraud clauses are common features in South African insurance contracts. Initially, we had adopted English law, which has changed in itself, but English law used to say that fraud unravels all. So if there was any fraudulent aspect in a claim, English law could refuse to pay the entire claim and claim anything back that they had paid. This was not South African law. South African law, only the fraudulent portion can be reclaimed because you've only been induced to pay the fraudulent part by fraud. So insurers wanted to have a similar provision in their policies so as to dissuade people from being fraudulent, and they introduced the whole concept of fraud clauses. The courts, being wary of a fraud clause, have interpreted them very strictly. And prior to this, they have said to insurers, you need to make it absolutely certain that it is supposed to be retrospective. In this particular matter, the Judge Arquo, the first judge, agreed that it was retrospective, but was just not prepared to enforce the fraud clause. So the Supreme Court of Appeal has now said, yes, you can have it retrospectively, but what you need to make sure is that the wording is such that it is clearly retrospective. If there's any ambiguity, they will find that it's not retrospective. The whole question of conventional penalties still hangs. I don't think a fraud clause allows one to invoke Conventional Penalties Act, but that still remains to be seen. Thanks. We now go on to Governor versus Guardrisk Insurance Company Limited. In Governor and Guardrisk Insurance Company Limited, the whole question of a reasonable precautions clause was raised. You'll be aware that there is an ongoing debate about the type of conduct of an insured that breaches a reasonable precautions clause, which is a term found in insurance policies. You will see the usual wording. The insured shall take all reasonable steps and precautions to prevent accident or losses. If that is strictly interpreted, reasonableness is negligence. So what the clause is saying is that if you're negligent, then you've breached the clause. There is a view, and you'll see it in the cases that I'm going to go through now briefly, that certain courts have said, and the English court certainly said, the whole point of a policy and a motor policy is to protect the insured from their negligent acts, and this would breach that. So the English courts have required recklessness. Now you will see in Gauteng there is an old decision which found that negligent is sufficient to breach a reasonable precautions clause. In KwaZulu-Natal, there's conflicting authority. One decision found that negligence will suffice, the case is there, whereas another has found that there needs to be intentional conduct. In the Western Cape, recklessness must be established, and the reason for this is, as I have said, because the purpose of motor cover is to cover the insured's negligence. So you need to prove recklessness, which requires the insured to recognize the danger to which he was exposed. And secondly, did the insured deliberately court danger by taking measures which were inadequate, or did he simply not care about their inadequacy or their adequacy? The SCA had the opportunity to set the matter right in Renasa, but because of other findings, it was not necessary to do so, and all that they had dealt with was the question of foreseeability. We can now go back to the Governor decision and the facts. The insured, accompanied by his mother, was involved in a single vehicle accident at night while it was raining. He was driving a Ferrari, and Guard Risk rejected the claim based on a breach of the reasonable precautions clause, as the insured was driving at excessive speed. The insured alleged he had been driving at 80 kilometers an hour and that he had aquaplaned. It is necessary at this stage to also inform you that the parties agreed that the effect of the reasonable precautions clause was that the insurer would only succeed in rejecting the claim if they could show that the insured was reckless, so that the facts and the attempts and the leading of evidence all were based on the question of recklessness. And I'll deal with the import of that or the meaning of that later. The court held that irrespective of the speed traveled, Guardritz has to show that the insured ought to have foreseen that there was sufficient water on the road to lift the car and cause a loss of control. This could not be established. The insured evidence that he was traveling at 80 kilometers an hour could not be excluded. His evidence of aquaplaning, although less likely at that speed, could also not be excluded. Also, an interesting aspect was the case had started out with the insurer's expert saying that by examining portions of material, they could show that the car had been speeding. But in discussions between the experts, it was found that the insurer's expert had dealt with a piece of Mercedes and not Ferrari as was involved with this, and it was clear that this was inappropriate. The speed limit, they say, on the William Nicol in that area is either 60 or 80. They weren't sure exactly where it was. I don't think it's necessarily reckless if you're exceeding a speed limit. It may be negligent, but you need to show something else with regard to recklessness and the foreseeability of what would happen. So the parties agreed recklessness must be established. Now, I think it's interesting to understand that I think that most attorneys dealing with insurance law recognize that although there are conflicting decisions in the various courts today, the courts would require recklessness. Correctly, they agreed that, because I'm sure what happened was the insurers did not want a judgment now determining whether it was recklessness, whether recklessness is required, and leave that open at least for argument in other cases. But I'm satisfied that if that came before a court today, the courts would find that a reasonable precautions clause means that you must not be reckless, and if one shows negligence, one has not breached that clause. We are still hoping for an SCA decision which will put an end to the debate, but I'm of the view that there is little debate in this regard, and that I would always advise insurers that they need to know that they are going to have to prove recklessness. Thanks. Is there any question that needs to be answered at this stage? Somebody said, is this not an easy escape clause for insurers? No, because they have to show recklessness. And that is not as easy as it may seem. So if insurers prove negligence, that will not be sufficient. And now we go on. Are there any questions at this stage? And then we now go on to our last case, Molefi versus My Way, and Paulette Khumalo.
Thank you, Mike. Good morning, everyone. Thank you so much for joining us. My name is Paulette Khumalo, and I am also an associate in the Johannesburg litigation insurance team. So the case that I'm going to discuss is also a little bit related to fraud, but just I think the way that the court dealt with it is a lesson for us rather than authority that we should rely on. So the facts in this matter are actually quite interesting and are something that's very much recurring a lot more and more these days. The insured in this case was out at a party. He made some money that day. He and his friend then went home with two unknown women. And unfortunately for him, he woke up the next day not remembering the events of the night, without a car, without his license, and without his clothes, actually. He recalled that he was dizzy, and when he found a way to get to the police, to call his family, he immediately went to the police station, reported his car as stolen, and the next day, while he was still dizzy and recovering from what he thought was having been drugged, he then lodged a claim with his insurer for the theft of the motor vehicle. Now, when he lodged this claim, he gave all of the information that he had at the time, so everything that he could remember, bearing in mind that at the time that he lodged the claim, it was one day after the incident, and according to his version of events, he had been drugged. So he was still dizzy, but he claims that he told the insurer everything that he remembered, and also mentioned that he was at a party, he was drinking, there was alcohol in his car. He doesn't remember whether it was open, whether he was drinking it in the car, but that there was alcohol there. They then considered the claim, and for some strange reason, even though his claim was corroborated, well, the facts were corroborated by his friend who attended the party with him. It was also corroborated by his cousin whose house he went to after the party. The insurer rejected the claim, and they said that according to the policy, he had signed, well, he had agreed that if anyone or himself acting on his behalf submitted a claim or any information or documentation relating to any claim, which is in any way fraudulent, dishonest, or inflated, all benefits under the policy in respect of such a claim will not be paid. So they said that in his story, he had not been sure of the time that he had left the party. So initially he had said he thought he left the party around midnight, but he then later on said in a WhatsApp message to the insurer's assessor that actually, when he thought about it, he appears to have arrived at his cousin's house at about 4 a.m. So he must have left the party later. He also had told them that he had been drinking that day and that there was alcohol in his car at the time that he lost his memory. The insurer said that there were discrepancies in his story, and therefore they said that he had been dishonest, and accordingly they wanted to invoke this clause, which allowed them to then reject his claim because of the discrepancies in his story. So what was strange about this case is that he went to court, and in the High Court, the court considered the facts, and bear in mind, in this case, the only version of facts that were before the court were the insured's version of facts, and the facts as led by his witnesses. The insurer didn't actually lead any facts to the contrary and solely relied on the fact that there were discrepancies in his story. For some strange reason, the court dismissed the insured's claim and said that, well, by not providing honest information, he had failed to prove on a balance of probabilities that his car had actually been stolen. And so they actually made a finding that he had claimed for a benefit that he wasn't entitled to. And so there was a finding that he had acted fraudulently in lodging this claim. And so he was not entitled to indemnification, and his claim was dismissed by the court. Strangely, the court also held that because he had withheld information when the claim was submitted, as soon as the dishonesty was discovered, then any predetermined condition for this clause to be enforceable was fulfilled. And therefore, the insurer's decision not to indemnify him was valid because it didn't matter whether or not the dishonesty in this case was material. Now, that matter went on appeal, and it was even stranger because the insurer didn't actually then have any representation in the appeal court, presumably because they thought that the court would not overturn that finding. The appeal court began its consideration by noting that fraud was never the insurer's case, and the issue of fraud should never have been considered because the claim had actually been rejected because of dishonesty and not fraud. So the question that should have actually been asked was whether the discrepancies in the insured's version of events were so material and prejudicial to the insurer that they entitled the insurer to repudiate the claim. And so on a balance of probabilities, the appeal court said, well, as soon as this man, came to and he realized that he had been robbed, he reported the theft to the police first without having been prompted by the insurer at all. He then went to lodge the claim with his insurer, and he also complied and deregistered the vehicle, listed it as stolen. And at the time that he had lodged the claim, he had told him that there was an alcoholic beverage. He told them that he had consumed alcohol during the evening. And so he had been honest in his account of whether or not there was alcohol in his car. And the issue of where the alcohol was and whether it was open or not wasn't actually of any consequence. He also gave his unqualified assistance to the assessors, and he volunteered further information as he began to remember it. And his version of events was corroborated even more by his friend, who confirmed in his evidence that he also suffered dizziness and what appeared to be the result of having been drugged for at least 2 weeks after the incident. So any dispute regarding the facts in this case, the court said that there were no facts that were put forward by the insurer to dispute the fact that the insured had in fact lost his car. And so there was no reason why the first court found that the car had not been stolen. So then the next question was, were the discrepancies material enough that they were so momentous that they could cause prejudice to the insurer? And that only in that event would the insurer have been allowed to reject the claim for the dishonesties. The appeal court found that these discrepancies were not material because they were actually neutral to the question of whether or not the insurer was liable for this loss. And so there was no basis on which the insurer could have rejected the insured, or should have, rejected the insured's claim. Just a warning though, if you are going to read this case, like I mentioned in the beginning, this case is not very good authority for the considerations for material or dishonesty at claim stage, because the court, even though the appeal court reached what we think is the correct decision ultimately, the way that they got to it was incorrect because the authority used related to dishonesty at the inception of the policy and not at claim stage. So for authority's sake, we wouldn't recommend using this case per se, but the reason, the conclusion should be heated, and where an insurer tries to reject a claim or intends to reject a claim for dishonesty, it does need to be material. I think, Mike, would you like to add anything to that? I think you probably have a lot of comments on this.
I like to discuss it because I think the floor needs to perhaps consider what's going on. The judgment is awkward because when they discuss the whole concept and say, well, it wasn't material, the test they use is materiality as envisaged by Section 53 of the Short-Term Insurance Act, which says the non-disclosure or misrepresentation must be material. Now that's a test at the renewal or the start of a policy, and that you have then to show that you were induced. What I think the judge is saying is there was nothing in what he did or said which was calculated to make the insurer make a payment to which he was not entitled. So let us discuss various facts that one perhaps could have not disclosed to the insurer, which in no way affects whether they pay the claim or not. So an insured is embarrassed because perhaps being married, he had a lady in the car, as possibly this chap had. Well, that fact would not stop an insurance company from paying the claim. It's what I would call a neutral fact. It wouldn't, by telling the insurance company or not telling the insurance company, they wouldn't not pay a claim if there's somebody in the car that had no effect on whether the car was stolen or not. So that sort of a fact, they're saying that where he may have got times wrong, where he may have got the order of something wrong, there was no intention on that insured to mislead the insurance company, with the result that the insurance company would pay a claim which should not be paid. And that, I think, is what he's talking about when he talks material. It doesn't affect the question of whether the insurer or insured pays the claim. And I think that is quite an important point that we need to understand as to why he made that finding.
Thanks, Mike. I think there are some questions in the.
I was looking at the question. I've got a question now. What's the position when the insured vehicle is driven by a driver employed by the insured? Well, that very much depends on what the wording of the policy is. You may have a situation where, let us say, the insured vehicle is driven by an employee, but the term is such that no matter who drives the vehicle, that person may not have an alcohol limit, and they're tested and they're over the limit. So it's very much the wording of the policy. There's a case where the insured vehicle is driven by an employee, and the story that that driver gives is not true and may have induced insurers to pay or not to pay, but the wording of the policy is such that it requires the insured not to do that, and that a driver can never be regarded as the insured. The insured must be somebody in managerial positions. So where you want to rely on a clause affecting the driver, then you need to put in the policy and is not driven by somebody who does the following. Or there's an exclusion which says if the driver does the following, then liability is excluded. And you make it sure that the breach is by the driver and not by the insured. I don't know if that answers. Let's see if there's any other question.
I did see a raised hand, Mike,
Yep.
but I'm not sure who it was.
I'm on the sort of questions. Let's see what.
Miguel or Michelle and Vili, you guys are welcome to turn your mics on for the questions.
Okay. Yeah.
Sorry, I don't have a question.
Okay.
Okay, no questions.
There is that one question which I see here, which we could perhaps consider. I don't know. Should vehicle extras be specified and accepted by insurers and an additional premium charge? Is there any valid reason for insurers to reject a claim based on the extras not being in the vehicle manufacturing specs? To note, these extras are purely cosmetic and vehicle was involved in theft and recovery and was not being driven on public road. Well, there are a whole lot of things. If the extras in the view of the insurer are a risk to the vehicle, so the extras are, let us say, supercharging a vehicle unnecessarily or in a manner that would be deemed to be unsafe, and the insurer would say, well, if I knew that was there, I would never insure the vehicle, well, then that's the answer. If the extras are a smarter electronic system or something like that, and it doesn't affect the safety, then the only question that I suppose one might have is whether there's a case for average, or whether those extras are covered at all, and so that they weren't disclosed to the insurer, and the insurer said, well, I don't have to insure them, and just ignores them. I don't know if that answers the question.
I think it does, Michael. Thank you. For the person that did ask the question, if you would like to engage, please just put up your hand and we will. Okay, he says they do.
I said I've got a yes, thank you.
Yes, yes.
Well, if there are no more questions, I thank you all for being very patient listeners. And if the contact covers a person from negligent, how do we just, sorry, there's one more question. I saw if the contract, sorry, there was a further question, but then it disappeared.
Are you looking for the one from Belinda? If the contract covers a person for negligent acts, how do we enforce jewelry safe warranties?
Well, a warranty is something quite different. A warranty overrides any of the other clauses. So a warranty says we will put jewelry, let us say, in the safe. Now, that doesn't matter whether we're negligent or not negligent. If the jewelry is not in the safe, it's not covered, period. And you may have, and that is a whole new lecture that we're going to be giving in due course on warranties. What is the court's view of a warranty where the warranty is breached, but is not at all related to the loss, is not related to the cause? And I think that is a whole new ball game that we need to discuss, and it requires a long discussion. And it wouldn't be possible for me now just to cover that.
I guess that means you guys will be back again soon, Michael.
I'm sure we will.
I see we've got
but it is an interesting point because warranties have been treated in one way for a long time. And then there was an SCA decision a few years ago saying, be careful, we as the SCA don't like it if there's no relationship to the loss. So there's a breach of warranty, that I breached the warranty, but the loss happened in a completely different manner and isn't related at all to the breach. The courts are not liking that, but that it does require a different discussion.
Perfect. And maybe just one question from me to you guys. So these are all cases that are listed in the big red book, correct?
Correct.
So how does a broker, how do we get our hands on it so we can read up some more on any of those cases that are available?
Okay, please won't you contact Bev, and we'll see if we can get copies of those books out to people.
Okay, perfect. Thank you very much, Michael. And team, thank you so much for the very insightful conversation this morning. I think we really need to unpack some of the other cases that are in the big red book. It makes for interesting education for us and the brokers, just to be aware of the things that do go on in case of law. But thank you very much for your time. Thank you for sharing your information. Thank you to the entire Norton Rose Fulbright team. We really do appreciate you, and we thank you to all our brokers that are joining us on Zoom and on Teams. And have a great iTOOsday further.
I thank you for listening to us, and thank you all, and thank the speakers as well.
Thank you.
Cheers.
Bye, everyone.
Bye.
Thanks, everyone. Goodbye.